I'm now going to read the chapter on civil rights from Title 18, Crimes and Criminal Procedure, Part 1, Crimes, as it can be found at https://uscode.house.gov/browse.xhtml. This is Chapter 13, Civil Rights. We have Section 241, Conspiracy Against Rights, Section 242, Deprivation of Rights under Color of Law, Section 243, Exclusion of Jurors on account of race or color, Section 244, Discrimination against person wearing uniform of armed forces, Section 245, Federally Protected Activities, Section 246, Deprivation of Relief Benefits, Section 247, Damage to religious property, obstruction of persons in the free exercise of religious beliefs, Section 248, Freedom of access to clinic entrances, Section 249, Hate Crime Acts, Section 250, Penalties for civil rights offenses involving sexual misconduct, and these are all criminal charges at the United States level for violations of civil rights. 241. Conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another, with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years, or both, and if death results from the acts committed in violation of the section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any terms of years or for life, or both, or may be sentenced to death. This is the very first one, Section 241, Conspiracy Against Rights, under Chapter 13 for Civil Rights. And I'm going to continue to read the other sections which are relevant to the concern that I brought up with police and multiple police reports, and for which I have a longer type-up. Section 242, Deprivation of Rights under the Color of Law. 242, Deprivation of Rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race, than are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year, or both, and if bodily injury results from the acts committed in violation of the section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years, or both, and if death results from the acts committed in violation of the section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title, or imprisoned for any years or for life, or both, or may be sentenced to death. For both 241, Conspiracy Against Rights, and 242, Deprivation of Rights under the color of law. Deprivation of rights under color of law. There are amplifiers for aggravated sexual abuse and the attempt to kill, which make it able to be imprisonment for any term of years or for life, and with an option for the death penalty. What this also means is that there is no statute of limitation to find those people within the state of California. That is part of state of California law. So this is still open to find them. 245, Federally Protected Activities. Nothing in this section shall be construed as indicating an intent on the part of Congress to prevent any state, any possession or commonwealth of the United States or the District of Columbia for exercising jurisdiction over any offense over which it would have jurisdiction in the absence of this section, nor shall anything in this section be construed as depriving state and local law enforcement authorities of responsibility in prosecuting acts that may be violations of this section and that are violations of state and local law. No prosecution of any offense described in this section shall be undertaken by the United States except upon the certification in writing of the Attorney General, Deputy Attorney General, the Associate Attorney General, or any Assistant Attorney General specially designated by the Attorney General that in his judgment a prosecution by the United States is in the public interest and necessary to secure substantial justice, which function of certification cannot be delegated. Nothing in the subsection shall be construed to limit the authority of federal officers or a federal grand jury to investigate potential violations of the section, to investigate possible violations of the section. B. Whoever, whether or not acting under color of law, by force or threat of force, willfully injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with, 1. Any person because he is or has been, or in order to intimidate such person or any other person, or any class of persons, from A. Voting or qualifying to vote, qualifying or campaigning as a candidate for elective office, or qualifying or acting as a poll watcher, or any legally authorized election official in any primary, special, or general election. B. Participating in or enjoying any benefit, service, privilege, program, facility, or activity provided or administered by the United States. C. Applying for or enjoying employment or any prerequisite thereof, any agency of the United States. D. Serving or attending upon any court in connection with possible service as a grand or petite juror in any court of the United States. E. Participating in or enjoying the benefits of any program or activity receiving federal financial assistance. 2. Any person because of his race, color, religion, or national origin, and because he is or has been A. Enrolled in or attending any public school or public college. B. Participating in or enjoying any benefit, service, privilege, program, facility, or activity provided or administered by any state or subdivision thereof. C. Applying for or enjoying employment or any prerequisite thereof by any private employer or any agency of any state or subdivision thereof, or joining or using the services or advantages of any labor organization, hiring hall, or employment agency. D. Serving or attending upon any court of any state in connection with possible service as a grand or petite juror. E. Traveling in or using any facility of interstate commerce, or using any vehicle, terminal, or facility by any common carrier by motor, rail, water, or air. F. Enjoying the goods, services, facilities, privileges, advantages, or accommodations of any inn, hotel, motel, or other establishment which provides lodging to transient guests, or of any restaurant, cafeteria, lunchroom, lunch counter, soda fountain, or other facility which serves the public and which is principally engaged in selling food or beverages for consumption on the premises, or of any gasoline station, or of any motion picture house, theater, concert hall, sports arena, stadium, or any other place of exhibition or entertainment which serves the public, or of any other establishment which serves the public, and I, which is located within the premises of any other of the aforesaid establishments, or within the premises of which is physically located in, or within the premises of which is physically located any of the aforesaid establishments, and 2, which holds itself out as serving patrons of such establishments, or 3, during an incident to a riot or civil disorder, any person engaged in a business or in commerce or affecting commerce, including but not limited to any person engaged in a business which sells or offers for sale to interstate travelers a substantial portion of the articles, commodities, or services which it sells, or where a substantial portion of the articles or commodities which it sells or offers for sale have moved in commerce, Or 4, any person because he is or has been in order to intimidate such person or any other person or any class of persons from A, participating without discrimination on account of race, color, religion, or national origin in any of the benefits or activities described in subparagraphs 1A through 1E or subparagraphs 2A through 2F, or B, affording another person or class of persons opportunity or protection to so participate, or 5, any citizen because he is or has been, or in order to intimidate such citizen or any other citizen from lawfully aiding or encouraging other persons to participate without discrimination on account of race, color, religion, or national origin in any of the activities described in subparagraphs 1A through 1E or subparagraphs 2A through 2F, or participating lawfully in speech or peaceful assembly, opposing any denial of the opportunity to so participate, shall be fined under this title or imprisoned not more than 1 year, or both, and if bodily injury results from acts committed in violation of the section, if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years, or both, and if death results from acts committed in violation of the section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years or for life, or both, or may sentence to death. As used in the section, the term participating lawfully in speech or peaceful assembly shall not mean the aiding, abetting, or inciting of any other persons to riot or commit any act of physical violence upon any individual or against any real or personal property in furtherance of a riot. Nothing in subparagraph 2F or 4A of the subsection shall apply to the proprietor of any establishment which provides lodging to transient guests, or to any employee acting on behalf of such proprietor with respect to the enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of such establishment, if such establishment is located within a building which contains not more than 5 rooms for rent or hire, and which is actually occupied by the proprietor as his residence. C. Nothing in this section shall be construed as to deter any law enforcement officer from lawfully carrying out the duties of his office, and no law enforcement officer shall be considered to be in violation of this section for lawfully carrying out the duties of his office or lawfully enforcing ordinances and laws of the United States, the District of Columbia, any of the several states, or any political subdivision of a state. For purposes of the preceding sentence, the term law enforcement officer means any officer of the United States, the District of Columbia, a state or political subdivision of a state who is empowered by law to conduct investigations of or to make arrests because of offenses against the United States, the District of Columbia, a state or a political subdivision of a state. For purposes of this section, the term state includes the state of the United States, the District of Columbia, and any commonwealth, territory, or possession of the United States. 247. Damage to religious property, obstruction of persons in the free exercise of religious beliefs. A. Whoever, in any of the circumstances referred to in subsection B of this section, intentionally defaces, damages, or destroys any religious real property because of the religious character of that property or attempts to do so, or 2. Intentionally obstructs, by force or threat of force, including by threat of force against religious real property, any person in the enjoyment of that person's free exercise of religious beliefs, or attempts to do so, shall be punished as provided in subsection D. B. The circumstances referred to in subsection A are that the offense is in or affects interstate or foreign commerce. C. Whoever intentionally defaces, damages, or destroys any religious real property because of the race, color, or ethnic characteristics of any individual associated with that religious property, or attempts to do so, shall be punished as provided in subsection D. D. The punishment for violation of subsection A or C of the section shall be 1. If death results from acts committed in violation of the section, or such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, a fine in accordance with this title, and imprisonment for any term of years or for life, or both, or may be sentenced to death. 2. If bodily injury results to any person, including any public safety officer, performing duties as a direct or proximate result of conduct prohibited by this section, and the violation is by means of fire or explosive, a fine under this title, or imprisonment for not more than 40 years or both. 3. A bodily injury to any person, including any public safety officer, performing duties as a direct approximate result of conduct prohibited by this section, results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, a fine in accordance with the title, and imprisonment for not more than 20 years, or both. 4. If damage to or destruction of property results from the acts committed in violation of the section, which damage to or destruction of such property is in an amount that exceeds $5,000, fine in accordance with its title, imprisonment for not more than 3 years, or both. And 5. In any other case, a fine in accordance with its title, and imprisonment for not more than 1 year, or both. E. No prosecution of any offense described in this section shall be undertaken by the United States, except upon the certification in writing of the Attorney General or his designee, that in his judgment or prosecution by the United States is in the public interest and necessary to secure substantial justice. Is in the public interest and necessary to secure substantial justice. F. As used in this section, the term religious real property means any church, synagogue, mosque, religious cemetery, or other religious real property, including fixtures or religious objects contained within a place of religious worship, or real property owned or leased by a nonprofit, or religiously affiliated organization. G. No person shall be prosecuted, tried, or punished for any non-capital offense under this section unless the indictment is found or the information is instituted not later than 7 years after the date on which the offense was committed. There's a question here that if a specific region of a person's brain is used for a form of personal spiritual practice, and that region of that person's brain was damaged, specifically and with specific intent to prevent that person from having their personal spiritual practice, whatever that may be, it is worth bringing forth the question of if this would then be able to count as a religious real property. Damage that specific region of the brain. This is something that should be thought about in depth, regardless of the application of this charge. This is something that should be thought about for the possibility of application for this charge. This is a question of brain matter. It first has to count as property. Property is my own. If I use portions of my mind for spiritual practice, they were damaged by someone trying to desecrate me, which was a term used in Berkeley, California, to have me desecrated. I'd like to know if this counts. 248, freedom of access to clinical entrances. A, prohibited activities. Whoever 1. By force or threat of force, or by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person because that person is or has been, or in order to intimidate such person or any other person or any class of persons from obtaining or providing reproductive health services. 2. By force or threat of force, or by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship. Or 3. Intentionally damages or destroys the property of a facility, or attempts to do so because such facility provides reproductive health services, or intentionally damages or destroys the property of a place of religious worship, shall be subject to the penalties provided in subsection B and the civil remedies provided in subsection C, except that a parent or legal guardian of a minor should not be subject to any penalties or civil remedies under this section for such activities insofar as they are directed exclusively at that minor. B. Penalties. Whoever violates the section shall 1. In the case of a first offense, be fined in accordance with this title, or imprisoned not more than 1 year, or both. And 2. In the case of a second or subsequent offense, after a prior conviction under this section, be fined in accordance with this title, or imprisoned not more than 3 years, or both. Except that for an offense involving exclusively a nonviolent physical obstruction, the fine shall be not more than $10,000, and the length of imprisonment shall be not more than 6 months. or both. And for the first offense, and the fine shall, notwithstanding section 3571, be not more than $25,000, and the length of imprisonment shall be not more than 18 months or both. For a subsequent offense, and except that if bodily injury results, the length of imprisonment shall be not more than 10 years, and if death results, it shall be for any terms of years or for life. C. Civil remedies. 1. Right of action. A. In general. Any person aggrieved by reason of the conduct prohibited by subsection A may commence a civil action for the relief set forth in subparagraph B, except that such an action may be brought under subsection A1 only by a person involved in providing or seeking to provide, or obtaining and seeking to obtain services in a facility that provides reproductive health services, and such an action may be brought under subsection A2 only by a person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship, or by the entity that owns or operates such place of religious worship. B. Relief. In any action under subparagraph A, the court may award appropriate relief, including temporary, preliminary, or permanent injunctive relief, and compensatory and punitive damages, as well as the cost of suit and reasonable fees for attorneys and expert witnesses. With respect to compensatory damages, plaintiff may elect at any time prior to the rendering of final judgment to recover, in lieu of actual damages, an award of statutory damages in the amount of $5,000 per violation. 2. Action by Attorney General of the United States. A. In general. If the Attorney General of the United States has reasonable cause to believe that any person or group of persons is being, has been, or may be injured by conduct constituting a violation of this section, the Attorney General may commence a civil action in any appropriate United States District Court. B. Relief. In any action under subparagraph A, the court may award appropriate relief, including temporary, preliminary, or permanent injunctive relief and compensatory damages to persons aggrieved as described in paragraph 1b. The court, to vindicate the public interest, may also assess a civil penalty against each respondent. 1. I. In an amount not exceeding $10,000 for a nonviolent physical obstruction and $15,000 for other first violations, and 2. In an amount not exceeding $15,000 for a nonviolent physical obstruction and $25,000 for any other subsequent violation. 3. Actions by state attorneys general. A. In general. If the Attorney General of a state has reasonable cause to believe that any person or group of persons is being, has been, or may be injured by conduct constituting a violation of this section, such Attorney General may commence a civil action in the name of such state as parens patria on behalf of natural persons residing in such state in any appropriate United States District Court. 5. Relief. Any action under subparagraph A, the court may award appropriate relief, including temporary, preliminary, or permanent injunctive relief, compensatory damages, and civil penalties as described in paragraph 2b. D. Rules of construction. Nothing in this section shall be construed. 1. To prohibit any expressive conduct, including peaceful picketing or other peaceful demonstration, protected from legal prohibition by the First Amendment to the Constitution. 2. To create new remedies for interference with activities protected by the free speech or free exercise clauses of the First Amendment to the Constitution occurring outside of a facility, regardless of the point of view expressed, or to limit any existing legal remedies for such interference. 3. To provide exclusive criminal penalties or civil remedies with respect to the conduct prohibited by the section, or to preempt state or local laws that may provide such penalties or remedies. Or 4. To interfere with the enforcement of state or local laws regulating the performance of abortions or other reproductive health services. E. Definitions as used in this section. 1. Facility. The term facility includes a hospital, clinic, physician's office, or other facility that provides reproductive health services and includes a building or structure in which a facility is located. 2. Interfere with. The term interfere with means to restrict a person's freedom of movement. 2. Intimidate. The term intimidate means to place a person in reasonable apprehension of bodily harm to him or herself or to another. 4. Physical obstruction. The term physical obstruction means rendering impassable ingress to or egress from a facility that provides reproductive health services or to or from a place of religious worship, or rendering passage to or from such a facility, a place of religious worship, unreasonably difficult or hazardous. 5. Reproductive health services. The term reproductive health services means reproductive health services provided in a hospital, clinic, physician's office, or other facility that includes medical, surgical, counseling, or referral services relating to the human reproductive system, including services relating to pregnancy or the termination of a pregnancy. 6. State. The term state includes the state of the United States, the District of Columbia, and any Commonwealth, territory, or possession of the United States. The main concern with this one is that I was being followed to appointments, and it is my understanding that the people following me were doing this to convince healthcare workers not to help, to lie to me about damage, and to say that nothing was wrong when there was a lot of damage which was visible. This kept me in a state of injury, kept me in a state of suffering, and made it more difficult to seek help elsewhere. I watched people follow me to multiple medical appointments where the healthcare worker then lied. This included a neurologist in San Francisco, a neurologist in Berkeley, and at the hospital at AHS Highland in Oakland, California. I watched people do this, and this was being done socially, as if I did not have rights. These are the laws that make it criminal to attempt to prevent me from having rights. This is in general and for all people. I am simply protected in my rights. This should be further noted for the attempt to prevent description for the purpose of obstructing justice. This made it more difficult for me to seek help from the police, put my life in further danger, and was led to and allowed for further injury. This is not only for brain damage, but for reproductive health as well. There are injuries intended to affect my ability for love and reproduction. This is literal for both. There should be unilateral support for not ever having this happen, and there should be unilateral support for finding everyone involved. 249. Hate crime acts. A. In general. 1. Offenses involving actual or perceived race, color, religion, or national origin. Whoever, whether or not acting under color of law, willfully causes bodily injury to any person, or through the use of fire, a firearm, a dangerous weapon, or an explosive or incendiary device, attempts to cause bodily injury to any person because of the actual or perceived race, color, religion, or national origin of any person, A. Shall be imprisoned not more than 10 years, fined in accordance with this title, or both, and B. Shall be imprisoned for any term of years or for life, fined in accordance with this title, or both, if 1. Death results from the offense, or 2. The offense includes kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse, or an attempt to kill. 2. Offenses involving actual or perceived religion, national origin, gender, sexual orientation, gender identity, or disability. A. In general. Whoever, whether or not acting under color of law, in any circumstance described in subparagraph B or paragraph 3, willfully causes bodily injury to any person, or through the use of a firearm, dangerous weapon, or an explosive or incendiary device, attempts to cause bodily injury to any person because of the actual or perceived religion, national origin, gender, sexual orientation, gender identity, or disability of any person. 1. Shall be imprisoned not more than 10 years, fined in accordance with this title, or both, and 2. Shall be imprisoned for any terms of years or for life, fined in accordance with the title, or both, if 1. Death results from the offense, or 2. The offense includes kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse, or the attempt to kill, or an attempt to kill. B. Circumstances described. For purposes of subparagraph A, the circumstances described in the subparagraph are that 1. Conduct described in subparagraph A occurs during the course of or as a result of the travel of the defendant or the victim. 1. Across the state line or national border. Or 2. Using the channel, facility, or instrumentality of interstate or foreign commerce. 2. The defendant uses a channel, facility, or instrumentality of interstate or foreign commerce in connection with the conduct described in subparagraph A. 3. In connection with the conduct described in subparagraph A, the defendant employs a firearm dangerous weapon, explosive or incendiary device, or other weapon that has traveled in interstate or foreign commerce. Or 4. The conduct described in subparagraph A. 1. Interferes with commercial or other economic activity in which the victim is engaged at the time of the conduct. Or 2. Otherwise affects interstate or foreign commerce. 3. Offenses occurring in the special maritime or territorial jurisdiction of the United States. Whoever within the special maritime or territorial jurisdiction of the United States engages in conduct described in paragraph 1 or paragraph 2A without regard to whether that conduct occurred in a circumstance described in paragraph 2B shall be subject to the same penalties as prescribed by those paragraphs. 4. Guidelines. All prosecutions conducted by the United States under this section shall be undertaken pursuant to guidelines issued by the Attorney General or the designee of the Attorney General to be included in the United States Attorney's Manual that shall establish neutral and objective criteria for determining whether a crime was committed because of the actual or perceived status of any person. 5. Lynching. Whoever conspires to commit any offense under paragraph 1, 2, or 3 shall, if death or serious bodily injury, as defined in section 2246 of this title, results from the offense, be imprisoned for not more than 30 years, fined in accordance with this title or both. 6. Other conspiracies. Whoever conspires to commit any offense under paragraph 1, 2, or 3 shall, if death or serious bodily injury, as defined in section 2246 of this title, results from the offense, or if the offense includes kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse or an attempt to kill, be imprisoned for not more than 30 years, fined in accordance with this title or both. B. Certification requirement. 1. In general, no prosecution of any offense described in the subsection may be undertaken by the United States except under the certification in writing of the Attorney General or a designee that A. The state does not have jurisdiction, B. The state has requested the federal government assume jurisdiction, C. The verdict or sentence obtained pursuant to state charges left administratively unvindicated, the federal interest in eradicating bias-motivated violence, or D. The prosecution by the United States is in the public interest and necessary to secure substantial justice. D. A prosecution by the United States is in the public interest and necessary to secure substantial justice. 2. Rule of construction. Nothing in the subsection shall be construed to limit the authority of federal officers or a federal grand jury to investigate possible violations of the section. C. Definitions in this section. 1. The term bodily injury has a meaning given such term in section 1365H4 of this title, but does not include solely emotional or psychological harm to the victim. D. The term explosive or incendiary device has a meaning given such term in section 232 of this title. 3. The term firearm has a meaning given such term in section 921A of this title. 4. The term gender identity means actual or perceived gender-related characteristics. And 5. The term state includes the District of Columbia, Puerto Rico, and any other territory or possession of the United States. D. Statute of limitations. 1. Offenses not resulting in death, except as provided in paragraph 2. No person shall be prosecuted, tried, or punished for any offense under this section unless the indictment for such an offense is found or the information for such offense is insinuated not later than 7 years after the date on which the offense was committed. 2. Death resulting offenses. An indictment or information alleging that an offense under this section resulted in death can be found or instituted at any time without limitation. E. Supervised release. The court includes, as a part of a sentence of imprisonment imposed for a violation of subsection A, the requirement that the defendant be placed on a term of supervised release after imprisonment under section 3583. The court may order, as an explicit condition of supervised release, that the defendant undertake educational classes or community service directly related to the community harmed by the defendant's offense. Section 250, penalties for civil rights offenses involving sexual misconduct. A. Offense. It shall be unlawful for any person to, in the course of committing an offense under this chapter or under Section 901 of the Fair Housing Act, 42 U.S.C. 3631, engage in or cause another to engage in sexual misconduct. B. Penalties. Any person who violates subsection A shall be 1. In the case of an offense involving aggravated sexual abuse, as defined in Section 2241, or if the offense involves sexual abuse, as defined in Section 2242, or if the offense involved an attempt to commit such aggravated sexual abuse or sexual abuse, fined under this title and imprisoned for any term of years or for life. 2. In the case of an offense involving abusive sexual contact of a child who has not attained the age of 16, of the type prohibited by Section 2244A5, fined under this title and imprisoned for any term of years or for life. 3. In the case of an offense involving a sexual act, as defined in Section 2246, with another person without the other person's permission, and it does not amount to sexual abuse or aggravated sexual abuse, be fined under this title and imprisoned for not more than 40 years. 4. In the case of an offense involving abusive sexual contact of the type prohibited by subsection A1 or B of Section 2244, but excluding sexual contact through the clothing, A. Fined under this title and imprisoned for not more than 10 years, and B. If the offense involves a child, who has not attained the age of 12 years, imprisoned for not more than 30 years. 5. In the case of an offense involving abuse with sexual contact of the type prohibited by Section 2244A2, A. Fined under this title and imprisoned for not more than 3 years, and B. If the offense involves a child under the age of 12, imprisoned for not more than 20 years, and 6. In the case of an offense involving abuse with sexual contact through the clothing of the type prohibited by subsection A3, A4, or B of Section 2244, A. Fined under this title and imprisoned for not more than 2 years, and B. If the offense involves a child under the age of 12, imprisoned for not more than 10 years. The point of this, and reading this, is simply that it is my civil right not to have this happen, and that it does not matter who the other people are. 241 covers normal people, neighbors, other students, faculty, other normal individuals, faculty or normal individuals, and the 242 is for law enforcement and other more official parties. Rights are based upon me. They are meant to be a shield and are guaranteed to have, by law, on the basis of citizenship and citizenship alone, as stated within the 14th Amendment of the United States Constitution. The language for this is clear. There are criminal laws involved in attempting to remove this from a person, and the ones read are the ones which are relevant to my extended experience, for which there is complaint, and for which I have police reports. As an additional statement, for each charge for which there is an option for amplification, my experience with this and concern and grievance, for which I again have police reports, did include aggravated sexual abuse or attempt to commit aggravated sexual abuse, and I do see this as having had an intent to kill, which does amplify the charge, and that needs to be observed.